This program is brought to you by Emory University.
It's my pleasure to introduce Professor Randee Waldman. You know that we searched all over the state for good speakers for our topics, and the good news is we didn't have to go far to find Randee. She is part of the Barton Center faculty. She directs our Juvenile Defender Clinic. Her bio information is available to you in its long form on the material, so I won't read all of that to you. But I'd note that Randee is a widely received speaker both at the national and regional levels, so it made really good sense just to turn around and find her and pluck her for our purposes here locally. And so with that, I would please join me in welcoming Randee Waldman, and we'll dive into the content. Is that yours? Yes.
Good morning. It's extraordinarily exciting to be here actually talking about the content of the new juvenile code after spending about 6 or 7 years talking to you all about what might be in the new juvenile code. So it's really exciting to actually talk about what's there. As Melissa mentioned, I'm going to be talking about the delinquency and the competency sections. That probably means about 1 hour and 50 minutes on delinquency and about 10 minutes on competency. There are a couple of important factors there, but really not too many. So I want to focus on what has changed in the delinquency section, which is really what I'm going to be focusing on today. As Melissa mentioned, we're going to start out by trying to take questions as we go along. If it gets to break time, we'll break at about 10 o'clock, and I realize I haven't gotten through any material because you've all asked too many questions. I'll probably change that practice up for the second half, try and make sure I get through all of the material, and then take questions if any time remains. So with all that said, I'm going to start off with with the natural starting place, which is the purpose clause. As you've heard over the last couple of sessions, one of the things that the new code has done is added a purpose clause to each and every article. So there's an overarching purpose clause of the code itself, but then there's a purpose clause of each of the articles. What you'll notice is that the purpose clause is really long. So I got some complaints about the handouts because the writing is really, really, really tiny. That's because the purpose clause is really, really, really long, and I tried to fit it on one slide. The very short version of these 6 bullets, which are fairly literal out of the code, is that what the code is trying to do with respect to delinquent children is balance 2 things. Balance the rehabilitative potential of the child with accountability and protection of the community. Right? That's actually said a lot of different ways, but each of those bullets really boils down to those 2 things. So we want to provide services for the child. We want to do that in the least restrictive environment that we can, but we also want to make sure that the youth is held accountable and that the communities remain safe. And so that's going to be a driving principle throughout all of the provisions that we have within the code. A couple of important things that start off the session, right? Parties. That has been a big open question mark in the current law. Who's a party? We all knew that the kid was a party, the juvenile was a party in delinquency proceedings, but then we had some case law that said the parent was a party. What does that mean? Does the parent need counsel? Nobody's really sure. Nobody ever gave the parent counsel, but it was out there. It was an option. And so what we've done is we've clarified who the parties are. Right now, the parties are the juvenile and the state. That is it. That's who has rights. That's who the parties are. With 2 additional notifications. Non-parties who have a small amount of rights. So what we have is parents who have the right to notice, the right to be present in the courtroom, and the right to be heard. And it's at all stages, right? So the parent is not a party. They can't appeal. They don't get to cross-examine witnesses, but they do at all stages of the hearing, at detention, disposition, and the way I read this, at the adjudication hearing as well, they get to be heard if they have something to say. And then there's a section that talks about DJJ. DJJ has the right to be notified of a disposition hearing, right? So we have 3 different categories of people. There's full-on parties, There's not so much parties, but the right to be heard, and then the right to notice for DJJ. Another really big change, the role of the prosecutor. So again, as you all probably know, although some of you might not really have been aware of this, prosecutors are not in every single courtroom in the state of Georgia in juvenile court. In fact, prosecutors need to be invited into the courtroom under current law. The code changes that. Every delinquency hearing will now be conducted by a prosecutor. One thing that does, it takes our probation officers away from practicing law without a license, right? In some counties, our probation officers were in charge of presenting cases. That seemed a little wrong to some people, and a little unfair to our probation officers, to be honest. So right now, prosecuting attorneys are now conducting all hearings on behalf of the state. Prosecuting attorneys are entitled to access to all files, right? It makes sense if you're actually representing the state and representing a party, you get to access all files. You get probation files, court files, hearing transcripts, delinquency reports, and any other juvenile court record that's going to be relevant to the child as you're prosecuting the case. And the prosecuting attorney is required to file all petitions. I wrote the word attorney here because it doesn't actually say the word prosecuting attorney. There's some cross-references going on within this code section, and it's really a prosecuting attorney or a designee of the prosecuting attorney, which most of you don't need to know the details or logistics of. If anyone has specific questions about how that works, I'm happy to answer them. So we talked about, again, different parties, who's represented where. This is one of the ones that becomes confusing, right? So what I said at the beginning is I'll answer all your questions. I'll answer all your questions to the extent that there are answers and that they can be readily identified. This is one that's still out there. There are some things, as you've learned along the way, that probably need to be clarified in the implementation stages. Current law talks about the right of the child to have counsel. That's a right that was given to all juveniles by In re Galt back in the 1960s. But in current law, a large majority of juveniles waive their right to counsel, and they're permitted to do so. In fact, all juveniles are permitted to waive their right to counsel under current law. Under the new code, most juveniles, well, let's go with some, there's two categories of juveniles. There's juveniles whose liberty is at stake and juveniles whose liberty is not at stake. The $10 million question, what does that mean? Don't know. As a defense attorney, as somebody who really cares about juveniles being represented, it is my position that every single time a juvenile walks into a courtroom, their liberty is at stake. I do not know that everybody will agree with me on that interpretation. I think that is something that we will either need to clarify when we clarify provisions next session, or something that's going to work its way through courts as we try and figure out what that means. So, what does that mean? Any juvenile whose liberty is at stake, regardless of what that means, I think for sure we know that it means anybody who can be locked up, anybody who can be detained in secure confinement. Those juveniles may not waive counsel at all. It can't be informed consent. It can't be, you may not, if you're a juvenile whose liberty is at stake, so anybody who commits a felony or above, may not waive counsel. A juvenile whose liberty is not at stake may waive counsel. Again, who those juveniles are, a little bit unclear. It might be the misdemeanor kids. It might be nobody, depending upon how broadly we interpret liberty at jeopardy. Access to records. How many of you have represented a kid, tried to get his file, couldn't get a parent to sign a records release, and never were able to get a file for the kid? A couple of us. So the resolution for this, we have, this was one that was important to me, that we spent a lot of time trying to craft a remedy that would make sense, that would meet the needs of the prosecutors, but would also meet the needs of the defense attorney. A defense attorney who is representing a juvenile in juvenile court has if they file a motion with a judge, and when they file that motion, they attach consent from the child not consent from the parent, but consent from the child to access that child's records, the judge shall, this is not a discretionary decision, the judge shall issue an order permitting access to those records. Why is this important? Many of us have represented kids whose parents are the complaining party. Shockingly, those parents aren't quite that welcoming and don't spend a lot of time signing our authorizations for release of records. They don't spend a lot of time giving us HIPAA releases. It is essential to the representation of a juvenile, as those of you who have done it know, that you have their school records and that you have their mental health records. And if you can't get a parental consent, you are stuck. This provision gives us an out. As long as the kid says you can have my files, the judge is mandated to provide an order for you, giving you those files. Those files are yours. They are not the prosecutor's. Those files are not the court's. It is an order releasing those records to you that should be compliant with both HIPAA and with FERPA, the education release and the medical release. Timeline. We're going to go over each of these stages in greater detail as I go through the process. But to start off, the process looks a lot like the process does in the current code with one small exception. And the timelines are a little bit different as well. So let's take a child who's not detained. Kid's never been detained, never been locked up, goes down to intake officer releases them, they're at home. The timelines look a lot like they do right now. The petition alleging delinquency needs to be filed in 30 days after the kid is released. There's an arraignment hearing. This is new. Some of us have arraignments, some of us don't have arraignments. I've been to a number of counties, they all look different. There is now a requirement that 30 days after the filing of the petition for a child who is not detained, that there is an arraignment hearing. After the arraignment hearing, there's an adjudicatory hearing, which happens 60 days after the filing of the petition, so essentially 30 days after the arraignment. And then there's your disposition hearing, which happens within 30 days of the adjudicatory hearing. A note about timelines. This is one of those areas that just needs to be clarified. Current law says that a lot of these events have to be scheduled within a certain period of time. It does not say they have to be held within a certain period of time, right? So the conversation with the judge is, Your Honor, I'd like this to be scheduled within the timelines of 30 days. They're like, great, but we're not hearing anything. Because it doesn't have to be heard. It just has to be scheduled. Depending upon which section of the new code you read, sometimes it has to be held and sometimes it has to be scheduled, and it's just contradictory. So in the timeline section, in the section that I refer to here, a quick note about my slides, the section that I'm referring to is actually right under the heading in each top right corner. The section that I referred to here, which is the timeline section, all hearings are to be held. And then there are some provisions within the code for continuances for good cause and what counts as good cause and when you can get one. All of the sections that describe the actual details of these hearings and when they have to happen say they must be scheduled. That can't be rectified with each other. I think that's something we just have to fix when we fix it in cleanup. There's contradictory information out there. Kid is in custody. Kid goes to intake, the kid gets detained, the kid is locked up, and the kid is in custody. This hasn't changed much as far as the process. There's still the detention hearing, the petition, the adjudicatory hearing, and the disposition hearing. What has happened is a change in timelines. So right now that our detention hearing has to be held within 72 hours. Under the new code, if the kid is detained with an arrest warrant, so probable cause has already been determined, they have 5 days to hold the detention hearing, not 3. If a kid is detained without an arrest warrant, the hearing has to be held within 2 business days. So, and that's because we need to have probable cause hearing. There are some exceptions within the code that talk about the fact that if 2 days falls on your weekend, their judge can have a probable cause review. I'll give you some details. There's actually a slide a little bit later about that, about the specifics of the process. But the timeline for detention hearings has been shifted and is highly dependent on whether there's an arrest warrant or not. Intake, right? Intake is now memorialized as a process within the code with some specific obligations to happen at intake. At intake, there's kind of a mini arraignment going on by the intake officer. A child does not have to be brought to intake. A child can be just given a date for an arraignment, but if a child is brought in front of an intake officer, the intake officer must inform the child of the contents of the complaint, of the nature of the proceedings, of the possible consequences or dispositions, and of their due process rights. I've listed out the due process rights they have to list here. There are a lot more slides where I just use the word due process rights. When you're referring to the word due process rights, come on back to this slide, because this is the one that actually tells you what they are. It's the right to an attorney, the privilege against self-incrimination, the right to confront and cross-examine witnesses, the right to testify, the right to compel other witnesses to attend and testify, the right to a speedy adjudication hearing, and the right to appeal and be provided with transcripts. Every intake officer, when a kid shows up, has to inform every child of each and every one of these rights. And they're supposed to do it in language understandable to the kid. So it's really not, here's a form, here's what you got. It's really supposed to be an explanation and a notice of rights that the child has. At intake, the detention officers are going to be using a detention assessment. How many of you are in counties? I'm trying to make you all alive. How many of you are all in counties where there's a detention assessment instrument that's used? A couple. How many are not in counties where there's a DAI used? How many have no idea what I'm talking about? All right. Like half of you still haven't raised your hand. So you're just comatose and I haven't woken you up yet. So detention assessment instrument as a concept is used nationwide. Sometimes it's called a risk assessment instrument. It's used as a concept in order to have some objectivity in our decisions of who gets detained and who gets released. So it's objectivity and consistency. There's a research-based tool that is designed to make sure that every child who is in the exact same situation as another child is treated the same way. And the decisions about whether we detain the kid are based upon the objective criteria rather than the kid who sits in front of us and what you think of them that day, or what kind of mood you're having that day, or any other non-objective criteria that might influence you. Right now, all of our dependent courts, so all of our courts who work closely with DJJ, where DJJ runs intake, use a detention assessment instrument, and several of our independent courts use one. Not all of them, so that's why some of you raised your hand, some of you didn't. Those of you who don't practice in delinquency just don't know what we do with our kids. The delinquency kids, the DAI that's used right now is an instrument that was created by DJJ many years ago. It has not been tested. I think DJJ just wrote a document. It's actually a pretty good document. Having looked at DAIs across the nation, it's not a bad one, but it certainly doesn't meet the definition that's been put in place in the code. So there's going to be a new DAI. My understanding is that DJJ is in the process of drafting that. They're working on making sure that it meets the definition, that it has been tested scientifically or actuarially or however it is that people test these things. And that's going to be used by every single intake officer in making the decision of whether to detain a child or not. So there will now be consistency across our counties throughout the state to determine who's being detained and who's not being detained, so that it'll matter less on which county you're in and more on what it is you've done and what your history looks like. Where a kid can be detained. This doesn't change too much, but I thought it was important that we talk about this. A child may be detained, a delinquent child, an alleged delinquent child, may be detained in a licensed foster home, in a home approved by the court, in the home of a non-custodial parent or relative, in a facility operated by a licensed child welfare agency, in a secure or non-secure residential facility, and if they're 15 or older, they may be held in a jail for up to 24 hours if certain conditions are met, right? So I say that one all quickly. The real short version of that is if a kid lives really far away from an RYDC, there is a provision in the code that they can be detained in an adult jail for a short period of time until they can get them to an RYDC with all of the obligations that our National Juvenile Justice Delinquency Prevention Act requires, which is sight and sound separation, so they can't be housed with or near adults. And by sight and sound, it's not that they can't be housed with, it's that they can't see or hear the adult population. And there needs to be continuous 24-hour monitoring and supervision of the child. So those are our federal obligations with respect to kids who are in adult facilities. Those are in place here, and there are a small number of kids. When you map out the counties, it doesn't actually cover all that many kids, but there are a small number of kids where it's just really quite impractical for the counties to get the kid on over to an RYDC that quickly, and that exception is in there for that reason. There is a code provision that says your placement is supposed to be in the least restrictive facility. Right, so we're not supposed to start straight on up with our RYDCs unless the kid needs to be in an RYDC, much like the education concept, right? There are some kids who need to be really restricted, some kids who don't, and we're supposed to figure that out. We're supposed to be using our DAIs to figure that out, and we're supposed to make the RYDCs for our most needy children or our kids most in need of restriction. And in one of these other places, right, a home, a non-custodial home, possibly a non-secure facility for the kids who don't need to be secure. Detention hearing. It needs to be held within 2 business days of taking the child into custody. I mentioned this already, if there is no arrest warrant. So if probable cause has not previously been determined, judge hasn't signed a warrant based upon probable cause, the probable cause component and the arrest warrant and the detention component all have to happen within 2 business days. There's an out, I mentioned that. There is a probable cause review within 48 hours. I don't really know what that means. I think it means, and I've been told that there's a case in the adult setting that actually deals with this and says that it's constitutional, which is at some point within 48 hours of when the kid gets detained, if detention falls on a Saturday, Sunday, holiday, and we can't get to a judge within those 48 hours, the judge is supposed to review the file, not sure where or how, review the file and make a determination that there's probable cause. So if upon that review the judge says there's no probable cause, there's no hearing, there's no cross-examination, there's no live testimony, but there's a review within those 48 hours to at least make sure that someone other than the police officer and the detention officer or intake officer has looked at this kid's file. If there is an arrest warrant, yes? Hold on, there's a microphone coming to you.
Yes, we actually have that in Fulton County. We have the judges are giving kids that are held, are getting close to 48 hours over a weekend, or especially a long weekend. The files are sent to the judges, and the judges review the file. Some of them are released, some of them remain detained, but they are reviewed, and then they sign the order on the next business day they come in.
Excellent. So we have an example of this working, and I heard some are released, so it's not a pro forma review in Fulton County. So that's that. I mean, I'm guessing that's the process that's going to be used. There'll be an on-call judge for each weekend. That judge will get a packet of files on Sunday or Monday morning if it's a long weekend, and will make a determination of probable cause. So,
yeah, my question is, the new code says, as you have up there, the hearing shall be held no later than 2 business days if custody occurs without an arrest warrant. 2 business days is defined in the code as you would expect, non-weekends and non-holidays.
Right.
So it seems to me that the probable cause review within 48 hours is sort of contradictory to that, since it specifically provides for the hearing to take place within 2 business days.
Right. There's a distinction between probable cause review and detention hearing. So the detention hearing itself, when 2 business days happens within 48 hours, encompasses both a probable cause determination and a determination of whether the child needs to be detained. Probable cause as its own separate concept is a constitutional mandate that is required to happen within 48 hours. So if 2 business days of your detention hearing happens later than 48 hours because of the definition of business, which means any weekend, the code is now becoming compliant with constitutional mandates that we have a review of probable cause within 48 hours. So the judge will, there's still going to be a detention hearing at that 2 business day mark. So on Tuesday, there will still be a detention hearing. That kid is still entitled to be heard. Their attorney is still entitled to make arguments for release. But the probable cause component of it is being pulled out and separated out with the probable cause review that's going to happen within 48 hours. Now, Fulton has been compliant with constitutional mandates. Most of our counties have not. The mandate that probable cause be reviewed within 48 hours has been there for a very long time. There's a U.S. Supreme Court case called Gerstein v. Pugh that has said that for years. We just have been waiting for the 72 hours as our current code says. So this is an extra protection. It's an extra level of review that's triggered whenever 2 business days is beyond 48 hours. Does that make sense? Other questions on that? At the detention, one more question. Hold on, Mike's coming to you.
On a Friday, if the child's detained on a Friday, within 48 hours, the judge has to have a probable cause review?
That's correct.
So that'd be Saturday or Sunday?
That's correct. So a child detained on Friday has to have that probable cause review on Sunday by a judge. A child detained on Saturday gets his hearing on Monday. Child detained on Thursday, the judge has 2 options. Bring the kid in before the weekend, which they usually do anyway, even now, or do your separate review over the weekend and bring the kid for a detention hearing on Monday. All right, so much like we talked about the intake officer, the judge at a detention hearing now must read a kid a series of rights, right? So your detention hearing for your detained juveniles is now the equivalent of your arraignment hearing. The judge has to inform the child of the contents of either the complaint, or if a petition has already been filed, the contents of the petition. Most of the time at our detention hearings, it's the contents of the complaint because we don't have a petition yet. The nature of the proceedings, the right to make an application for bail. Bail is going to come to bail in a second. Possible consequences or dispositions, and their due process rights. Those are the same due process rights I listed at the intake stage. So right now at our detention hearing, our judges are providing a list of arraignment rights to our kids. That's new as far as I'm concerned. It might be happening in a couple of jurisdictions, but I've not seen that before. The detention decision, right? So probable cause, we talked about that, right? In order to continue to detain a child, there needs to be probable cause. That's old law, that's new law, that hasn't changed. Some of those reviews happen at different places, right? If there's an arrest warrant, probably don't need probable cause. If there's one of these reviews, you probably don't get to readdress it, although maybe you do. But the first stage is, in order for a kid to continue to be detained, there must be a finding by somebody that probable cause exists. Second, that clear and convincing evidence exists that the freedom should be restrained, that no less restrictive alternatives will suffice, and that, right? So the sort of overarching determination is clear and convincing evidence that freedom of restriction should be, freedom should be restrained. That's the current law. The and that is changing a little bit, right? Again, for those of us who practice in delinquency, we have sort of been confused by the fact that current law has 151146 and 151146.1, and they have two different standards, and they're contradictory standards, and nobody really knew what to do with that and which one was controlling on any given day. We now have one standard. That's a big improvement, and it combines a couple of the elements of both of those sections. So the first option, right, for when a kid can be detained is that the kid may inflict serious bodily harm. That's in current 46.1. This second bullet is new and comes a little bit from 46. 151146 talks about the protection of property of others. What this code section has done is made that a little bit more meaty. It has made a determination that it's, well, do we really need to protect all property? What kind of property? Under what circumstances? You know, every kid might be a danger to property at some time. So there's a little bit more meat here. So it says that there's a demonstrated pattern of theft or destruction of property such that detention is required to protect the property of others. Right? So now it's not, I would argue, the first time there's a property issue, but a demonstrated pattern, which might mean the second time. But I think it's not the first time based upon the way this is written. The way this is written is designed to give us, you have a kid who is constantly stealing things from others or punching holes into walls or doing something to damage properties. We need to keep this kid for a little while to make sure that this kid doesn't continue to damage property. But we need to actually make that determination that there's a pattern or practice in existence. And then, of course, to secure his or her presence in court, right? The whole abscond from the jurisdiction question. Bail. We currently have a provision in our juvenile code that says you have the same right to bail as adults. That provision continues to exist. It's been carried over into the new code. How many of you have ever gotten bail for a kid? One. Oh, two. All right. It's pretty rare, but it does exist. It will continue to exist. There's one caveat that's been written into the new code. The new code has created a provision that says you may only get bail, or you may only make your application for bail at intake or at your detention hearing. So if you're an adult and you're detained, you can keep coming back and making applications to reduce bail and making applications for bail, and you can do that anytime up until the day of your trial and up until the day that your guilt or innocence has been determined. That has been clarified in the juvenile setting. You may ask for bail at detention hearing or when you're with the intake officer, and that is the only time you may ask for it, and that is the only time it may be addressed. So, for those of you who are defense attorneys in the room, make your bail request the very first time you show up at your detention hearing because you don't get a second shot at that. The rest of this section here, they may be released on bail if the court finds. That's the adult standard that's been implicated, so that does not have an impact on 1511 or on the section before, which is 1511-503. That is the adult bail standard. So you get the same right to adult. You should be looking at your adult cases about what those provisions mean and what those caveats mean on when somebody can be released to bail. There shouldn't be too much, there's not supposed to be too much distinguishing factors based on the fact that it is a juvenile. Those are not limiting provisions on your detention hearing assessment. Petition. Petition shall be filed by an attorney, right? So I mentioned that earlier when we talked about the role of the prosecuting attorney. In our current world, petitions can be filed by anyone. So do not have to be reviewed by an attorney. Sometimes in the current situation, you have some prosecuting attorneys who see the petition and who see the file for the first time when the case is set down on the calendar. They're stuck arguing a petition that's been written by somebody else. That's not true in every county. In a lot of our counties, there's some prosecutorial review, and a prosecutor signs the petition and files the petition, but it's not mandated. It's now been mandated that a petition be filed by the prosecuting attorney, which means they have to review the file, which means they have to look at the evidence and make a determination. Somebody needs to make a determination before we're charging a kid with something, or somebody who's been trained in the practice of juvenile law is making a determination at this point that we should charge somebody with the offense. Some new requirements within the petition. Some old requirements. First off, within 72 hours after the detention hearing, within 30 days of the complaint. Some new requirements of contents, right? The old requirements are still there. You need the name, you need the address, you need the person whose custody and control they're in. Those are still there, but there are two things that need to be added. First off, the place of detention. Again, happens to me all the time. Who knows where my kid is? I don't, right? It's not listed anywhere. It's kind of hard to figure out. Right now, the petition is going to require, under the new code, that it lists where the child is. So if they're in an RYDC, you have to know that. If they're in a DJJ home, you have to know that. But wherever the child is at the time they were taken into custody has to be included into the contents of the petition. The second piece of information that's new is that the prosecutor has to list from the get-go whether this is a Class A or a Class B designated felony act. I'll describe the distinctions between Class A and Class B designated felony acts much later, but the concept right now is that there needs to be a warning moment on the petition. Oh yeah, this is a DF, right? I've tried to memorize the list of assorted designated felonies, but I'm not sure I've done a good job at that because there's a lot of them and they're kind of scattered and there's not really a lot of sense to what's a DF and what's not in some circumstances. And so every single time I get a new offense, I have to go look through my list of DFs and see if it's one of them. This will save that trouble because they have to list right in the petition, hey, by the way, this is a designated felony. You should be aware of that. Amendments. Our current code, one source of great dissatisfaction, our current code lets the state amend a petition at any time. What does at any time mean? After the evidence. I've had multiple prosecutors say, Your Honor, I'd like to conform the petition to the evidence. But I was actually defending a different charge, Your Honor. And some judges will let them change it, and some judges won't, depending upon what the change is. The code actually puts a stop to this. The petition can be amended at any time prior to the hearing. After jeopardy is attached, you may not amend the petition to allege new charges. Right? So jeopardy attaches. Jeopardy is actually defined in the new code as the swearing in of the first witness or after the admission. Once that's happened, once you've actually had your trial, once you've figured out what the evidence is, you can't say, oh, and by the way, that actually sounds like robbery and not burglary. We're going to amend the petition right now. No longer. That's out. Arraignment. An arraignment is going to be scheduled within 30 days of the filing of the petition for a child who is not detained. At the arraignment, the court shall inform the child of, right? You've heard this litany before. But instead of the contents of the complaint, now you're informing the child of the contents of the petition, and then all of the other things, the nature of the proceedings, the possible consequences or dispositions, and your due process rights. Some new provisions right after this that happen at arraignment. At arraignment, a child who is represented by counsel, right? So if your liberty is at stake, you have to be represented by counsel. Any child who has actually decided to seek counsel and who is represented by counsel may enter an admission at arraignment. If you do not have counsel, you cannot enter an admission at arraignment. If your liberty is not in jeopardy, at arraignment you can do the following things. You can say, I wish to waive counsel, right? So this is your moment to say, I want a lawyer, I don't want a lawyer. And if your liberty is in jeopardy, you get a lawyer, whether you want one or not. If your liberty is not in jeopardy, you can take this moment to say, Your Honor, I don't need a lawyer. I don't want a lawyer. I'm all good. Important to note, a parent cannot make that determination. I think I put that earlier in. A parent cannot waive a child's right to a lawyer. That decision must come from the child, him or herself. I think that's always been clear, but there's been some confusion about that within our current practice. A child whose liberty is not in jeopardy, there's also a provision in the code with respect to arraignments, may actually also say the words, Your Honor, I wish to waive counsel, and at the adjudicatory hearing that's going to be held in 30 days, I plan to enter an admission. So they can make a statement of intent about whether they're guilty or not guilty, delinquent or not delinquent, plan to admit or not admit, but they cannot go through the process of entering an admission right there at arraignment. So lots of questions about why this is. I don't honestly remember the decision-making process, and I'm not sure I was part of the decision-making process. This might happen late. But the concern among many of us is that you have a lot of kids who admitted arraignment because their moms don't want to come back again, right? So when mom doesn't want to come back again and you show up at arraignment and your choices are you can get a lawyer and come back again, or you can admit today, the choice has been, whether it's a free choice or not, why don't I just get this over with today? Because that seems like the easier way to go about it without really understanding the rest of what the implications are for making an admission. Whereas the requirement that they actually have to come back eliminates that extra moment of pressure, right? You have to come back anyway. So if you want a lawyer, you might as well seek one. If you don't want one, that's all good, and you can come back and admit next time. But if you want one, that's no longer the excuse of, but I just want to get it over with today. The compromise for allowing lawyers to admit at arraignment, sometimes it's in the kid's best interest to admit at an arraignment, and a lawyer can help that kid make that determination, right? And if a kid and a lawyer are sitting there together and make a determination that the kid can actually understands the consequences, knows what's going on, and still wants to go ahead and make that admission, with the presence of a lawyer, with the advice of counsel, that admission will be accepted at the arraignment process. This is a brand new provision, failure to appear. We'll keep trying to go interactive here for a moment. Failure to appear currently, 9/10, the judge is taking calendar call. Who gets the failure to appear warrant? No, kid, right? The kid gets locked up because they haven't shown up at 9:10 for a 9 o'clock calendar call. The code has actually put in some protections for the child who can't get there on their own. So the way that failure to appear warrants are going to work right now, if a parent fails to bring a child who is under the age of 16, and we'll talk about willful failure to appear later, but if a child is under the age of 16 and is not in court the morning of court at 9:10, let's say, or even at 9:45, what happens is that the judge issues a rule nisi ordering the person to show cause. So they order the parent, it's a rule nisi to the parent to show cause on why they weren't there and why they shouldn't be held in contempt. If the parent fails to appear in response to the order to show cause, that can result in a bench warrant for the parent, not for the child at this point. So if you have a child who is under the age of 16 and they are not there, step number one will go down, did the kid willfully refuse to appear? That comes into effect when a parent is in court and says, I am here and I tried real hard to get my child here with me, and he or she refused to come. In that circumstance, there's a bench warrant for the child. But if neither the parent nor the child is here, and the kid is under the age of 16, the conversation is with the parent. There's an order requiring the parent to show up, and if the parent fails to show up, there's a bench warrant for the parent to make sure that the parent is the one bringing the kid. It is awfully hard for most 14-year-olds to get to court on their own, and they're usually not the one with the calendar reminding them when to come to court. If a child is 16 or older and does not appear, the presumption is that child could get there on their own and is old enough to figure out how to get to court and when their court date is. There's a bench warrant issued for the child. So for your 16 and 17-year-olds who are still hanging around in juvenile court, bench warrant goes against the kid. If the kid is younger than that, there has to be a willful failure to appear in order for the bench warrant to be issued against the kid. And if the kid is 13 and doesn't show up, it doesn't matter how willful it is. There's no provision for a failure to appear warrant. So if you've got your 12 and 13-year-olds who just refuse to show up, no bench warrant. That's on the parent to make sure their kid comes to court. Questions about that? That's a brand new provision. Yeah. Jan.
Randee, what about a child who's in defects custody? You know, because the defects worker will always say the foster parent was supposed to bring him. The foster parent says the defects worker was supposed to get him there.
There's no provision that specifically talks about that section. My general understanding would be that the parent is defects and that defects is responsible, at which point the defects worker, right? So the first step is that you just get a failure. You don't get a failure. There's no bench warrant against the worker, right? The first step is that they're ordered to come to court at a second date. So I think the answer would be that it's the defects worker who is the parent at this stage, who has the rule Nisi to say, why haven't you brought the kid to court? I think that the takeaway for me is that in that circumstance, it's not the 15-year-old kid who's getting the bench warrant, right? When the adults are fighting over whose responsibility it is, our judges are probably going to let that slide once until they figure it out, until it becomes a pattern or practice, in which case our judges are going to get real mad and maybe do something. But right now, for me, the big issue is, right, it used to be your kid who got the bench warrant when the adults are fighting over whose responsibility it was to bring the kid to court. And the kid's like, I didn't know, I don't live anywhere near here anymore because I'm in defects in a different county. And so the kid's no longer at risk in that circumstance until they turn 16. But I'm not sure. My guess would be that it's the defects worker, but the judge can decide. Whoever it is they gave summons to the court before would be my guess. We're going to do a couple of more slides, and then we're going to take a quick break. So SB 440, the first concept here is that there is no change to our exclusive jurisdiction offenses. Our 7 deadly sins are still our 7 deadly sins. However, there has been a change with respect to which cases come back down to juvenile court with the option, which cases have the option of a hearing in front of a superior court judge to come back down. So the process of pre-indictment prosecutorial discretion still exists the same way it did before. For those of you who spent a lot of time talking about this and reading the code and worrying about SB 440 cases, the way the code is written right now, so current law, is that if you have an SB 40 offense that is punishable by life, which is all of them except voluntary manslaughter, you are at the mercy of the prosecutor. If the prosecutor did not wish to exercise their discretion, the case could not come down. What's been done with HB 242 in the new code is that they've reverted back to the status quo at the time SB 440 was written. So the reason why a couple of our sex offense cases, the aggravated sodomy, aggravated child molestation, and aggravated sexual battery cases got caught up in the judge could not hear the case and you were stuck with the prosecutor, is because after the law went into effect, the sentencing scheme for those 3 offenses changed, thereby impacting which cases could be brought down after hearing and which cases couldn't. So reverting back to the status quo of when the statute was drafted with the original intent of the statute, those 3 sex offenses, you may now have a hearing in front of a Superior Court judge. If you prevail at that hearing, that case gets transferred back down to juvenile court as a Class A designated felony. Again, we'll talk about those. That decision is appealable by the state, and that's actually treated as an interlocutory appeal. So the state can appeal that right then if they wish. Transfer to Superior Court, so not our SB 440 cases, but our straight up 15-year-old felony case where the prosecution decides this kid should be in the adult system. We've done everything we possibly can with this child. Our code today really doesn't actually, it says that we have to consider the best interest of the child and the community, and it actually says best interest of the child or community based on case law. There's now a series of factors that a judge is required to consider in making that transfer decision. So they are very similar to the Supreme Court decision in the U.S. v. Kent, which are the Kent factors. There's some modifications here. They fall into 2 broad-based categories: best interest of the child, rehabilitation potential of the child, and best interest of the community. But they are spelled out much more broadly, what it is that we're actually looking at, and trying to figure out which kids should be in the adult system and which should be in the juvenile system. There are some reports and evaluations that are available to our judges in this determination. So the first up is a probation report. That's supposed to develop available information relevant to the transfer criteria, so a judge can ask a probation officer to write a report and to go through each of these factors and make an analysis within their probation report based upon available records of where these factors come out. There's also something called a transfer evaluation. The sort of shorthand there is that it is of the clinical status of the child. What that really means, it's not just looking at their school records and their prior juvenile history, but it's stayed away from calling it a mental health evaluation. But it is, in essence, a mental health evaluation. It is an evaluation that is to be done by DBHDD, Georgia Region. It's to be done by a trained professional who can actually take a little bit of a more in-depth look about what it is that is going on with this child. What are the causes of delinquency to the extent that we can determine them? Are there any mental health issues? Is there anything going on that we can figure out a more in-depth look so a judge can make a more informed decision about whether to transfer the child? Any statements made during the transfer evaluation or the probation report or at a transfer hearing can only be used as impeachment or rebuttal evidence. So if a child makes an incriminating statement, child makes an admission during any of these evaluations, those cannot be used. This provision actually appears a couple of times within the context of the code. This is true also of intake, of your competency evaluation. Essentially, anytime we're actually trying to evaluate a kid to figure out what's going on, if they make an incriminating statement during those evaluations, they cannot be used against them absent impeachment, right? So if the kid then testifies to something contradictory, you can come back. Or rebuttal. Again, if the kid puts on an affirmative case that's contradictory to something they said, it can be used there. But other than that, you can't just have the evaluator get on the stand and say, hey, guess what, he told me he did it, and that can't be used against him. And I already mentioned this, decision to transfer is an interlocutory judgment and may be appealed by either party. So the same as the SB 440s. This is an interlocutory judgment, can be appealed, right? It doesn't mean you get an interlocutory appeal because you still need some permissions for that, but it can be taken as an interlocutory appeal. I'm going to break here, and we will come back in 10 minutes. My watch died yesterday, so I think somewhere around between 5 after and 10 after, we will be back. All right, we're going to go ahead and get started again. And before I continue with current slides, I have 4 questions that have been forwarded to me via the internet that I'm going to do my best to answer. So question number 1 is, what does it mean that the prosecuting attorney is entitled to the complete access to the court files? Does it mean that we're entitled to a copy for our files, or just entitled to view the files in the clerk's office? I don't know the answer to that, but my guess on interpretation of that is that you're entitled to view the files. I think it's the same concept as discovery for the parties, right? We're entitled to inspect and review all files. I'm not sure copying comes along with that, but I don't actually have I think the code is silent on whether you get a copy to keep in your own files or whether you just get to see all the documents, but my best guess is that you just get to see all the documents. If somebody has a better answer for that, I'm not 100% sure. Next question. Oh, sorry. I have the same question several times. What if a child admits using drugs to a probation officer, either during a screen or when questioned during a regular probation meeting? And that's about the incriminating statements that I mentioned. I believe that is not included, right? These are evaluative evaluations. So they're your initial intake conversations, your screenings, your competency evaluations, your transfer hearing evaluations. If you're actually just talking to your probation officer during a screening and you admit to using drugs, then you've admitted to violating your probation, right? I don't think that is protected by the concept of the incriminating statements protections. That's covered by the code itself. Lesser included offense. Can the court find that a child committed a lesser included offense after hearing evidence on an adjudicatory hearing? And how does that pertain to amending petitions? Yes, the court can always find a lesser included offense. That is not a notice requirement within the petition, right? You don't have to amend a petition to include a lesser included offense. That's always part of the charges that the kid can be found at the end. So that's not applicable to the amendment category. And Michelle, I think there was a 4th, but 2 of these appear to be the same. Or did I miss one? Oh, so the last question, which didn't come through, had to do with our probable cause hearing requirement again. And the question was, is the 48 hours requirement in HB 242, or is it just case law? And that is actually written into HB 242. So HB 242 specifically has a section that says if 48 hours, that if your detention hearing happens after the 48 hours provision, then that has to happen. The probable cause review has to happen within that time frame. And that is in the provision that's referenced on the slide that I talked about that on, and spelled out quite clearly in the new law. And then I had another question from Jan, who's left the room. So I don't remember what it was, but I'll try and clarify that one as well. Adjudicatory hearing. The adjudicatory hearing, if the child is detained, happens within 10 days of the filing of the petition. And again, remember my caveat there that it either happens within or is scheduled to happen within 10 days, and that's just a contradictory statement within the code provision that we're going to have to work out. In the section I reference here, 1511-580, that actually talks about scheduled, but in the previous section it talks about has to actually happen. If the child's not detained, it's within 60 days of the filing of the petition, and that hasn't changed at all. Understandable language. There is a provision in the new code in HB 242 that says the court shall address the child in language understandable to the child in order to determine whether the child is capable of understanding such statements about his or her rights. And then, if capable, the child enters a denial or admission. This is something that for sure law has required, but it's spelled out pretty clearly right here in the code that you can't just read through a real quick recitation of rights. You have to address the child in language that they understand, and you have to have a conversation to make sure that the child understands what it is that's happening, and then the child, before the start of the adjudicatory hearing, enters an admission or a denial. And then you go into the adjudicatory hearing. I don't have any slides on the adjudicatory hearing because the adjudicatory hearing happens the exact same way the adjudicatory happens today. There's absolutely no change. There's no amendments. It just goes on the exact same way. If you go to a hearing, you have all the rules of evidence apply as they apply in an adult setting. We still don't have the right to a jury trial in juvenile court, and everything else happens the same way that it happens today. So our disposition options, this is actually a really big change, and this is where I'm going to spend pretty much all of the time before we finish up today on the disposition options in the 3 different categories, or perhaps 4 different categories of offenders. Category number 1, what I'll call everybody, right? These are this is disposition options that are available to every single person who is charged with a delinquent offense in juvenile court. Doesn't matter what type of offense it is, the following things can happen to you. These look a whole lot like the disposition options that are available to our minor level offenders today, to our misdemeanor offenders today. The changes really start happening when we talk about the next level of things that could happen. So you can have any order that is available for a dependent child, except you cannot place a delinquent child in temporary de facto custody as a result of a delinquency hearing. So if what you're looking to do is place a child in temporary de facto custody, there has to be a corresponding petition alleging deprivation, or dependency, as we're now calling it. Otherwise, it cannot happen as a delinquency option. You can have counseling for the child, and this is a little bit different, and the parent or guardian, right? It's not just the child who can be ordered to counseling, it can be the parent or guardian as well. Supervised probation, including a probation management program. Probation management program, for those who haven't been using them, has been in our code for the last several years. And that includes a secure probation management program as well as a non-secure one that talks about graduated sanctions. This is new. Unsupervised probation. You may now have a child placed on a period of probation that is unsupervised. It means they do not have to report to a probation officer. It means that at the end of a period of time, if all has gone well with that child, without being on a probation officer's caseload, that case can be closed out. It is for our minor level offenders, our first-time offenders. It's to decrease the loads of probation officers who have very high caseloads with some kids who don't need as much monitoring as others, right? There are some kids who need to be talked to every day and some kids who are doing just fine without anybody. So there is now a new level that is called unsupervised probation. It would have to be in the order that's issued by the judge, and that could be a disposition option. Current code, again, you can be ordered to continue with your studies, either towards a high school diploma or a GED. A judge could do that today. Generally speaking, with our 16 and 17-year-olds who have dropped out of school, the judge can order that that be not the decision that they make going forward with their time. Community service, restitution, fines for our traffic offenses, and suspension of driver's license. Again, those are things that are pretty common in today's probation requirements, or disposition orders as well. Category number 2. I have called these felony and misdemeanor plus. So felony, we all know what that means. Misdemeanor plus, if you have a child who has committed 3 previous adjudicatory offenses, right? So this is their 4th adjudication, and at least one of those adjudications is a felony. Doesn't have to be the most recent, but one of the priors. Right? So you have a kid who commits a felony, but the judge just puts him on probation and doesn't do a whole lot. And now you're at adjudication number 4, and adjudication number 4 is a misdemeanor. That falls into this category that I've called misdemeanor plus. If you have a child who has committed 35 misdemeanors, could happen. Some of our kids are busy. They do not fall into this category. If you have a child, these are new offenses. If you have a child who has committed 35 violations of probation, does not fall into this category. It must be your fourth adjudication for an offense, and one of those offenses has to be a felony offense. Is that clear? All right. If you fall into that category, you can get all of the things that everyone can get, or you can be committed to a facility, institution, or camp for delinquent children. That's actually been in our code for felonies for a while. It's a little bit hard to understand what they are because we don't really have a lot of them, but think back to the days when we had boot camp. That's the kind of program we're talking about. If you have a program, a wilderness camp, if we actually create one that's not part of DJJ but is out there and created by the court systems as an alternative, you can do that. You can have commitment to DJJ, and you can have up to 30 days in secure residential facility or treatment program provided by DJJ or juvenile court. So, by implication, right, it wasn't on the previous list, it is on this list. What cannot happen to your misdemeanor kid? Commitment to DJJ, right? Our misdemeanor kids can today be committed to DJJ. They cannot after January 1st, 2014. That is a really big difference. Our current distinctions is between felony and aggravated misdemeanor or misdemeanor, right? So our high and aggravated misdemeanors fell into the category of felonies before. That distinction has been removed, right? So the high and aggravated misdemeanor, the very first time you have a battery on a school official, which is a high and aggravated misdemeanor, that is no longer in the category of felonies, right? So those kids are no longer eligible for 30-day short-term treatment programs. Clear? Questions? All right. Designated felonies. The list of designated felonies has not changed. So the sort of amorphous list of 20-plus charges that I mentioned earlier, that still exists the same way it did before, but there's been a breakdown in designated felonies. There are now two categories of designated felonies. They are Category A and Category B. So some basic requirements, and then I'll tell you what A and B are. The order has to be made within 20 days of a disposition hearing, same as today. There's a risk assessment to be completed, right? And this is something that DJJ is working on right now as well. This is much like our detention assessment instrument. This is something that is scientifically driven. It's research-based. It will be part of the decision-making process of who needs to be in restrictive custody as a DF. And you'll see when we get to the slides for Class Bs, whether you're low risk or high risk will have a big impact upon what your sentence can be, on what your disposition can be. And then your disposition order is to include findings based on a preponderance of the evidence, whether restrictive custody is required. If you're low risk, there have to be specific orders, specific findings as to why placement in restrictive custody is necessary. So if you go through this risk assessment instrument and your client and the child comes out low risk, there needs to be, and the judge says, I don't care how low risk you are, I'm locking you up anyway. There has to be a specific finding on the record why the low risk categorization should not trump and why the kid needs to be detained and placed in secure confinement. And there needs to be written findings with respect to each of the factors that are laid out here. They're very similar to the factors that are laid out in today's current code. So the dispositions, right? What can happen? If you are a Class B designated felony, these are our lesser, let's go here. You don't have to memorize this. It's in the code. It's right there in your slides for you. This is one of the slides that's actually kind of hard to read because it's got a whole lot of writing on it because we have so many designated felonies. Class A and Class B have been broken down roughly into violent and nonviolent, right? That was the concept that was going on in the creation of these two categories of felonies. Your more violent are your Class A designated felonies. Your less violent are your Class B designated felonies. There are a couple that look like they're on both sides. Criminal gang activity, it depends on exactly what type of gang activity you do. So you're a Class A for most, but if you're just doing tagging, it's a Class B. That's really the breakdown on those. Your fourth felony, right now your fourth felony is a DF. Your fourth felony, it's going to depend upon the type of felony that you've committed and depend upon whether it's a crime against person or a sex offense. And persons and sex offenses are in the A category and other felonies are in the B category. And that's defined much more clearly in the code, but again, the general concept being A, more serious offenses, B, less serious offenses. So having said that, here's what has to happen. Again, there's the basic statement in, so Class B designated felony, a judge first has to decide, are we seeking restrictive custody, right? Just like they do today, there's the preliminary, well, we're not going to seek restrictive custody analysis, at which case they get the felony misdemeanor plus options, right? So they get the everybody stuff plus the option of commitment to DJJ and the option of 30 days in a facility. If you're seeking restrictive custody for a Class B, you are committed to DJJ for up to 36 months. It is not a flat 36 months. It is up to 36 months. So a judge can make a determination of anywhere from 0 to 36 months on the commitment to DJJ. No more than 18 months of that commitment. This gets actually complicated because there's a lot of halves going on here. No more than 18 months of that DJJ commitment can be served in restrictive custody. So you have a kid who is a Class B designated felony, who has committed an offense, we'll call it their fourth nonviolent felony. They can be committed to DJJ for 36 months, with 18 of those to be served in secure confinement. The other 18, they're out in DJJ custody, just like your committed kid is. Now, within that categorization, a moderate or high-risk child, again, we have our risk assessment, and you fall into a category of low, moderate, or high. Moderate or high, at least half of that period of 18 months has to be done in a secure residential facility, also known as our YDCs. And the other half, they can be moved out into a less secure facility at the discretion of DJJ. Got it? If you are a low-risk child. Now, here's one of those typos in the new code. There's a word missing. It's a pretty important word. It just said non-secure residential facility and is missing the word shall or may. I believe contextually, if you read all of the things around it and if you read the way the first half was written, I believe it's a shall. But it's totally possible it's a may, and we're going to fix that going forward. But if you are a low-risk child, my interpretation of this is that all of your 18 months in restrictive custody is in a non-secure DJJ facility. So if you're medium or high, or moderate or high, half of your time is for sure in a secure placement, and the other half, DJJ can move you to a non-secure placement. But if you are low, and the judge says, I don't care how low you are, I still order restrictive custody, that placement is in a non-secure facility. So it's not the YDCs, it's some other place that doesn't have barbed wire and loud sounding, clanging locks coming out of it. After your period of confinement, there's a period of intensive supervision not to exceed 6 months. So say you're committed for 36 months, you spend 18 in secure confinement. When you're out after your 18 months are up, you have 6 months of intensive supervision, and then you'll have another 12 months of non-intensive supervision. Clear? lots of haves, lots of conditions. It's a lot more clear in Class A. Class A designated felonies. You are committed to DJJ for, again, if restrictive custody is deemed not necessary, you go back to the misdemeanor and everybody plus categorization. If restrictive custody is desired, if the judge orders restrictive custody, there is an initial DJJ custody for up to 60 months. Once again, you no longer have a mandatory 5-year commitment to DJJ. It can be anywhere up to 5 years. Could be a year, could be 4 years, could be 5 years, totally at the discretion of the judge. Child is confined in secure residential facility for any period set by the order, right? So we don't have all these haves and non-secure places and all that other stuff. If you are a Class A designated felon and your judge says you are committed to DJJ for 60 months, all 60 months to be in a secure facility, you are in a YDC for those 60 months. There's no more DJJ discretion. There's no more we can put you in non-secure. Your Class A designated felons are always going to remain in secure confinement for the period set forth by the order. What you'll see missing from this categorization is right now it must be for a minimum of 1 year. No minimums anymore. A judge can order a child placed in secure confinement for 3 months. They can place for 6 months. They can place for any number of time greater than 0 and less than 60 months within that continuum for your Class A designated felons. After your period of secure confinement, there's intensive supervision for a period not to exceed 12 months. And again, that should be set forth in the order how long you have for intensive supervision. But it cannot exceed 12 months. It does not have to be 12 months. Some new provisions with respect to children with developmental disabilities. If a child is ordered confined to restrictive custody, but diagnosed with a developmental disability and not amenable to treatment in a secure residential facility, DJJ may transfer to a non-secure residential facility, and they must notify the prosecuting attorney and the judge. They don't actually have to ask permission. They don't have to have a hearing. They just must notify. So if you have a child, right, the prime example of this kid is a kid with mental health issues, and those mental health issues are not being treated by DJJ in a secure facility. DJJ has recognized that and said, hey, this is not the kind of kid we should be treating, and we don't have the resources to do it. DJJ, at their discretion, can take that child and move them to a non-secure placement where that treatment and rehabilitation can be better provided. Notwithstanding the order of the judge. For this one, right, there has to be a developmental disability, and it does not appear as though there's a hearing. DJJ can just make a decision that there's a developmental disability, and they wish to remove that child from the secure facility into a non-secure facility to provide treatment and rehabilitation. That's the exception. The court loses jurisdiction over DJJ placement. I'm sorry, so the questions that are coming here is, notwithstanding the order of the judge, and does the court lose jurisdiction? The court does not lose jurisdiction any more than they usually lose jurisdiction over a DJJ committed kid. So to a kid who's committed to DJJ and DJJ decides home placement as compared to, right, your normal DJJ committed kid, not your secure confinement, they have jurisdiction over that kid to the extent that you have committed them to DJJ, but if DJJ wants to send them home instead of to river camp, wilderness camp, DJJ can do that. That's the same thing, that's the same kind of jurisdictional loss that happens when you commit a kid to a secure confinement facility. There's a microphone coming for you.
The court can't do a Rule 9 cite to DJJ, say show cause why you've done that.
I don't believe so. I think the same way, my understanding is that the court has no jurisdiction over DJJ, right? The same way the court has no jurisdiction over a DJJ placement now, the same way the court has no jurisdiction over DFACS now, right? If DFACS wants to place a kid somewhere, the court can't say that's not an appropriate placement, you don't get to place them there. To the extent that there's this out for DJJ, this out is outside of the jurisdiction of the judge. So, and it is a small, well, it's probably not that small an out because most of our kids probably have developmental disabilities, but it is an out that requires a finding that they are not amenable to treatment and rehabilitation within the facility and that they need to be placed elsewhere. And that out does remove them from the court's oversight, jurisdiction, and finding. Your microphone's coming. Just to let you know, so the question was, what's the purpose of the notification? To let you know what's happening. Just so you know, Judge. Just to aggravate us was the comment, and that might in fact be true. My reading of this is it's a shall, there's no hearing, there's no read, it's a notification, it's a courtesy. Just so you know, Judge, this is what we've done with your order. That was the final response. There is mandatory secure confinement. It doesn't say how long. I don't believe it says how long. I might be misremembering that, but there is mandatory secure confinement. It might be a year. I'll actually go back and double check that. If there's serious physical injury upon a person 72 or older. So there's no discretion. Right now there's some provisions for age. I think they're 62 now, which up your secure confinement period from 12 months to 18 months. The new code provision says that if you have injured somebody who is 72 or older, seriously injured somebody who is 72 or older, that discretion is gone. You must serve some time in secure confinement. Credit for time served, and I actually write this here, but it's actually a provision that exists throughout the code with one contradictory moment where it actually says something different. But as a general rule, in all of the other provisions that talk about credit for time served, all time spent in secure or non-secure residential facilities shall be counted toward confinement period. So everything pre-adjudication, from the day you get taken into custody to the day you serve the end of your order, all of that time is counted as credit for time served. And that's true in all calculations of credit for time served. There's a general provision about credit for time served that I think I actually left off of here, but it's sort of a catch-all provision for credit for time served that says just that. It says anytime you send in secure confinement or non-secure confinement, it does exempt out your alternative placements awaiting adjudication. So if you're actually sent to a group home or not home but not a secure confinement placement, it exempts that out. But everything else counts as credit for time served in secure confinement from the day you get taken into custody. Early release. The standard for early release has not changed at all, but you may file a motion for early release at the 6-month mark and every 6 months instead of at the 1-year mark and every 1 year. So if you really want to piss your judge off, keep coming back every 6 months. It's allowed, but I'd probably not recommend too much. 6 successive early release motions is probably not going to get you very far. No, so the question was regarding retroactivity. Although that might be. So here's the provisions within the code regarding retroactivity. Substantive provisions, all the things we've talked about disposition options. Substantive provisions are not retroactive. Substantive provisions take effect from the day the kid committed the crime, not from the day you're actually in court. So for your delinquency attorneys out there, we should not be delaying all of our delinquency dispositions just because we're waiting for January 1. It won't help us, right? The disposition options are from the day the kid committed the crime. Procedural changes are retroactive, just like procedural changes are retroactive in standard course of statutory construction. I actually don't know what an early relief motion would be. My guess is that that is substantive and that for your first filing, you might have to wait the year, but it might be that you then get every 6 months after that, because that seems like a procedural thing. But I'm just guessing at that, and I honestly don't know. I'd have to look at that a little bit more. Do you have a thought, Melissa? Yeah, so my guess is you might have to wait the first year on that. And then, I mean, it seems procedural of when you can file. That doesn't seem substantive to me. That seems procedural. But I'd have to maybe look at that closer and look at some adult corresponding sections on that to see what really it is. I'm just not sure. It's sort of that gray area between procedure and substance. Some additional noteworthy changes. There's just a couple of these that I didn't really spend a lot of time on, but I think are worth you knowing about. The first off, right now our code section has a provision that says when you take a child into custody, you can immediately take them to a hospital, to their home, or to intake. And that's it. So those of us who are defense attorneys spend some time cross-examining our police officers who have taken our clients to the station and say, is the station home? Is it the hospital? Is it intake? No? So you weren't authorized to take them there. Except that our case law said, guess what? They're authorized to take them there regardless of what statute says. So HB 242 dealt with that by saying, our case law says they could do it anyway. We might as well codify that. So the codification is that law enforcement may detain a child for a reasonable period of time. That's open to interpretation, I would imagine. Sufficient to conduct an interrogation or perform routine law enforcement procedures, fingerprinting, photographing, right? So they may now, by statute, bring our clients, bring the juvenile on over to the squad room, bring them over to the police station. They can do the interview, they can do the interrogation in a police station, they can fingerprint, they can photograph, and then they have to bring them home, intake, in front of a juvenile court judge, or a hospital, sorry. Second thing is victims' rights. There's a fairly large section about victim rights. The very short version of it is that they're entitled to the same rights, notices, and benefits as the victim of a crime committed by an adult. So all of the things with respect to victim impact statements that came into the code a couple of years ago in the adult section have been incorporated into the juvenile code as well. Victims are also entitled to notice regarding release from detention for designated felony acts. They actually have to opt into most of these. So the victim has to actually tell somebody that they want to be notified and that they want to assert their rights. And if they don't opt in, they actually lose their right to much of this notification. But the general concept is if a victim wants to be notified of what's going on, wants to make victim rights statements, there's some cross-examination going on there with respect to if a victim shows up in a courtroom to testify. All of that comes in from the adult section now. And then jeopardy, we talked about this a little when we talked about amending petitions. Jeopardy attaches if a child denies at the swearing in of the first witness, and if the child enters an admission as soon as the court accepts the admission. One thing that I actually saw happen with somebody who'd asked me some questions that we were trying to appeal is that sometimes the witness does not have to be the state's witness, right? If the state's not ready to go forward and the judge says, you're going forward anyway, if you are a defense attorney, you should actually not say, Your Honor, they didn't put on any evidence, we rest. Call a witness, because jeopardy attaches when you call a witness, right? Any witness. As long as there's a witness sworn in, jeopardy attaches. If there's no witness, there is no jeopardy at that moment. So keep that in mind. That's been codified. That was sort of the law before, but it was never codified in our code. Questions on delinquency? Question over here.
I think the provision that the judge can detain a child between adjudication and disposition, I thought that was still there. And if it's still there, then everyone's liberty interest is implicated, and there was no one who can opt out or admit at arraignment. Is that a correct analysis?
That's an open question, but that's my analysis, right? So that was when we talked. So the question. The question is who can waive counsel, right? What I said early on is it is my assertion as a defense attorney that every single child has his liberty interest at stake every single time they walk into a courtroom. Because if they look at the judge the wrong way, they can be held in contempt. If there's the opportunity to be detained for whatever reason, even if you're a misdemeanor client, even if you're a misdemeanor, facing a misdemeanor charge and you can't be detained at disposition, you can always be detained at a detention stage. I think the answer to that, I agree that the answer to that is yes. I also think that your liberty is at stake every time you're placed on house arrest, every time you're placed on probation, every time you're told you have a curfew, every time you're told that something you wish to do cannot be done in a way that the law would otherwise provide for somebody else to do it, your liberty is at stake. That's my personal interpretation. It is unclear to me that that interpretation is what was meant by the drafters. That's the interpretation that I read as being consistent with our habeas proceedings, right? Certainly your liberty is at stake for purposes of a habeas proceeding if you are under some restriction of a court order. I don't know what was meant by the drafters. I really don't. I'm not sure the drafters know what was meant by the drafters. It was a last-minute provision. I think that's something that's going to have to be worked out. I think that's something that the judges are going to have to figure out how they're going to apply that. I think we're going to have to see as that goes forward and possibly clarify when we do our cleanup bill in the fall or in January. Sure.
And thereby allow that child to proceed without counsel?
The question was, is it possible that the judge can telegraph, I'm going to put you on not reporting probation if you just go ahead and admit? Happens every day today, right? It happens, you have to trust the judge, but if the judge does something more and then the kid violates, can you undo the whole thing? Maybe, right? But a judge can always telegraph, right? It's happened to me in front of judges where I've asked for things and the judge has called us up to the bench and said, I can't tell you what I'm going to do, but I'm telling you, you might want to go forward today, right? That's happened. That's happened to every one of us who's practiced in front of a judge. I'm guessing that happens with right? It could happen from a negotiated agreement with a prosecutor where if you admit today, we're going to put you on non-reporting, unsupervised probation. And that might be seen, right? That might be the one circumstance, unsupervised non-reporting probation. But the question is, what happens when the kid violates it? When you violate your probation order, your liberty is at stake because they can bring you in and lock you up for violating your probation. And so for me, I don't even think that's enough, if that's the definition we're using. But it might be that that's the definition and that is enough. I just don't know, right? I think that's something we just have to play out.
Randee, you had one question that came in on this section on the email. So if Class B, designated felony, and child messes up during non-restrictive custody, is there any means to revoke or do anything to that child?
Yeah, I think the answer is always yes. I think that has not changed from current law. So let's say we have a Class B designated felony, and we place them on, and we decide that they don't need restrictive custody. And when we decide they don't need restrictive custody, the kid then violates the terms of probation, you revoke probation, and you send them to restrictive custody. That's true, I think, if we have a Class B and we decide to give them 6 months and then they mess up. At that point, I don't think that's true, right? I think if the judge gives them 6 months and they mess up during the remaining 12 months, I think that's a DJJ issue. And I don't think any of that changes from current law. So I think current law says if you actually just decide no restrictive custody at all, push you on probation, the judge can revoke probation and sentence you to, give you a disposition of secure confinement. Under current law, if the judge gives you secure confinement of 2 years but a commitment of 5, and at years 3, 4, and 5 you mess up, you are under the auspices of the DJJ commitment order and DJJ's internal due process rights of what DJJ wishes to do with you during your mess-up period. So I think once the judge enters an order that says commitment to DJJ instead of probation, it's DJJ's ball game if you mess up. And if a judge says probation, whether it's Class A or Class B, and you mess up, revocation is always an option. Hopefully that answers whoever's out there in the world. All right, so like I promised, about 10 minutes for incompetent to proceed. Our definition of competency has not, or incompetency as the case may be, has not much changed. Lacking sufficient present ability to understand the nature and object of the proceedings, to comprehend his or her own situation in relation to the proceedings, and to assist his or her attorney in the preparation and presentation of his or her case in all adjudication, disposition, or transfer hearings. Right? So what I just read there is the Dusky standard. That's the adult standard for competency. The section that we have that is different in our juvenile code, which is true in our current code as well as here, is that such terms shall include considerations of a child's age or immaturity. Right? So sometimes our kids are incompetent, not because of any inherent mental illness or inherent intellectual disability, but just because they're young. They just haven't grown up enough to understand what's going on around them. Something that's new, maybe, sort of. I think this was happening in some jurisdictions. It's new in our code and codified in our code and made very clear going forward, is that there is this thing called competency remediation services. They are outpatient, and that's very important, interventions directed only at facilitating the attainment of the competence to proceed. So, remediation services are designed to take a child who is not competent, right? They are not services about school. They are not services about community-based resources. They are services that are designed to take a child who doesn't understand court and make them understand court. That's their role. So if you have a child who doesn't understand because they are mentally ill, medication brings them to a point where they can actually assist their lawyer, participate in the process, and understand what's going on. That is remediation services. If you have a child who is just 11 or 12 and a little bit slower and didn't understand when they had their competency evaluation what the role of the judge was, what the role of the parties were, what they should use their defense attorney for, and then you have some classes. And you tell the kid every day for a week and a half, this is what it's all about, and then you test them, and they get it, they are now competent to proceed. That is what remediation service is for. They're not about anything else about this kid. They're not about making this kid behave better. They're about making this kid understand what court is about. So some general provisions about Article 7, which is our competency section. They're applicable in both chins and delinquency proceedings. I'm not talking about chins today, so we're only focusing on our delinquent kids, but you have to be competent to proceed in a chins proceeding as well, because your liberty, as I define it, is at stake in a chins proceeding. Competency evaluation can be ordered on the court's own motion or on a motion of any party, GAL, or parent guardian. So really anybody can raise the issue of whether a child is competent. If there's a child who is under the age of 13 who is alleged to have committed a serious violent felony, serious violent felony is not our designated felonies. There is a list in our adult code of a definition of serious violent felonies. For shorthand, it's basically our 7 deadlies, but there are a couple more that are applicable in that. If you have a child who is under 13 who has been alleged to have committed one of those, a competency evaluation must be conducted. All right, that's not a shall, that's not a may, it's a must be ordered. Court must appoint an attorney prior to an evaluation, so regardless of where we come out on this question of liberty at stake, if a child is deemed to, or is questioned to be incompetent to proceed, an attorney must be appointed before the competency evaluation is ordered. And a competency evaluation stays all proceedings. So all of those timelines we talk about, none of them start running while a child is being evaluated and during that evaluation process. Written report shall be submitted within 30 days of the court's order, and then there's all these caveats for when an extension may be granted. If the child is deemed not competent by the competency evaluator, and this is an opinion, it is not a finding, right? The judge still makes the finding. The evaluation must include an opinion as to the primary cause of the incompetency. So is it because of immaturity? Is it because of mental illness? Is it because of a developmental disability? What is it that's going on that's causing this child to not understand what's happening? And they have to propose an opinion, provide an opinion as to whether there's a substantial probability that they will attain competence in the foreseeable future. Foreseeable future is not defined by the statute, but in case law, that's the same provision we've been using forever. It's generally thought to be about a year. Question over here. Michelle's running.
So the competency remediation services, are those just for the kids who are found where competency it will be attained, or is it going to be every child?
I'm going to tell you that in a second. I'm going to answer that. So the question is, when do you get remediation services? And I'm going to answer that. The judge is going to have some choices. The judge is going to choose to proceed under chins or choose to try and remediate. And that's going to, some of that depends on who the kid is. So competency hearing happens within 60 days after the court order for evaluation. The burden is on the child to prove that they are not competent to proceed. The standard of proof is a preponderance of the evidence, and the examiner is considered the court's witness, subject to cross-examination by all parties. That's fairly consistent with our standards right now. So what happens? If the evaluator opines and the judge agrees, even if the evaluator doesn't opine, but the judge finds that competence can be remediated, the court may do one of several things. The court can dismiss without prejudice or order competency remediation services. So the court can actually always dismiss the petition at some point if the child's found incompetent. Court shall consider probable cause, the nature of incompetency, the age, and the nature of the alleged act. So the court can actually make a decision and decide, you know what, the kid can be remediated, but this isn't really that big a deal, and I don't want to go forward with this as a delinquency adjudication. If there's a dismissal, it's without prejudice, and then you'll find out on our next page, the judge can also order that this goes to chins. Oh, actually, that's unrestorably incompetent. I take that back. If they're restorably incompetent, the court can just dismiss if they think it's going to take too long. Or they can order remediation services, right? If the court says, you know what, this is such a minor shoplifting offense that I don't want to spend our money going through remediation services for a minor shoplifting offense, I'm going to go ahead and dismiss the petition, even if they could be remediated. The timelines, so they're here. If competency remediation services are ordered, the court retains jurisdiction. These are the same timelines we have right now. So for a misdemeanor, it's up to 120 days, 4 months. For a felony, it's 2 years. So you could have 2 years of trying to remediate a felony adjudication, right? So the kid's not competent, they're 13. You spend 2 years doing remediation services, they're now 15. Right before that 2-year mark, you want to go forward with the adjudication, you can do so. If they're detained in a secure or non-secure residential facility, so if the kid has been detained at the outset, the judge must issue an order releasing that child within 5 days of a finding of competency. Who picks the kid up and where they go is another question that's open for a whole other level of debate. But the child may not maintain, an incompetent child may not maintain in a secure residential facility or a non-secure residential facility once the finding of incompetence has been made, and the judge has 5 days to issue an order. Well, they have 5 days to get the kid out, depending on where the order is. If they are unrestorably incompetent, the opinion of the evaluator, the judge agrees, and the child is unrestorably incompetent, the court dismisses the petition, appoints a plan manager, and orders that child to be proceeding under chins. That's the basics of what is going on with the incompetent kids. The general distinction right now, it's very similar to what we have currently, with the exception of we're actually trying to restore kids. So right now what we have is if the kid is unrestorable, they go into a dependency proceeding, which has a plan manager, and we figure out what we're doing with them, and we provide them services in the community, and if somehow they become competent in the time period, we can go forward with that adjudication. Now we're actually making a decision at the outset. Restorable, unrestorable. Unrestorable, you immediately go this way to CHINS, which has a whole bunch of provisions about how you handle them. Restorable, you can actually always move from restorable to unrestorable along this continuum, so an evaluator can find, or the remediation provider can find along the way, you know what, we thought we could fix this, we thought we could make this kid understand, but he just ain't getting it. And they can become unrestorable, and your unrestorable can go into your CHINS petition, but if they're restorable, they could hang out in this remediation category for a little while.
So Randee, who's going to be providing the restoration services, and is it going to be a uniform program across the state? I mean, or will each jurisdiction be responsible for doing their own?
The remediation services?
Yes.
My understanding is that each jurisdiction is responsible for their own remediation services, and that DBHDD is trying to set up a series of programs and classes, and my understanding at the outset of it was that DBHD was going to help out with that process, but I don't think that's required by the code at all, and that is required by each jurisdiction, right? Which is sort of where we are now, which means that if a judge says, I don't want to remediate, they just move them on over to CHINS, right? If there's no remediation services to work on that process, you can move them on over to CHINS. There are some requirements, but it doesn't have to be a psychologist, it doesn't have to be an educator. You could have like 12 college kids working with a group of restorably competent kids in a classroom, teaching them the role of the attorney, the role of the judge, the role of the prosecutor, the idea and the concept behind plea bargaining. And if it works, as long as they report on it and we actually come back and everyone agrees the kid now understands, they'll go back to an evaluator, and the evaluator will assess that they understand. That's a required final step, is back to the evaluator to figure out if they are now competent and to opine on whether they are now competent. But that middle step is up to each jurisdiction to figure out how to run, I think. All right, is out of time. Thank you all for coming. I hope you learned something.
Again, thank you all for coming. Just by way of final announcements, please stop by the registration table if you need to pick up anything or resolve anything with respect to your CLEs or certificates. Also to return in your evaluation of today's program in exchange for a parking voucher, and take care of any other of those administrative details. And then stay tuned. As I mentioned before, we'll have a session in September at a date to be determined on CHINS, and then we'll be back again in November for a conversation about child hearsay. So the September program will conclude our series on the code, but obviously this is an ongoing conversation as we all adjust and prepare to implement the new law. So have a great day, and thanks for coming.